all persons having any manner and form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. Sorry for the delay, but we had to gather together for a few minutes downstairs. We have two cases here, and good lawyers. We look forward to it. In the U.S. Medic Supplies versus Gericare. Mr. Farrell?
Yes, Your Honor.
Good to have you with us.
Good to be here again, Your Honor. A short thumbnail sketch of this case. My client, the plaintiff, reached agreement with Gericare, the defendant, to be the sole and exclusive supplier to Saudi Arabia of products distributed by Gericare and made available to U.S. Med. It only took 2 weeks for that exclusive agreement to be interrupted by an exclusive agreement agreed to between Gericare and another distributor, Courtroom. There's a quote in this case that's very important. In the testimony of the executive VP sales manager for Gericare, Mr. Friedman. Mr. Friedman has testified, this case will be determined by whether the court decides Gericare, the defendant, had a contract with U.S. Med, the plaintiff. I would agree with Mr. Friedman's prognosis of this case, and a valid contract was deemed to exist with regard to U.S. Med, the plaintiff, being the sole agent for the export of Gericare products to Saudi Arabia. All sales of calcium carbonate, specific product of Gericare, would be exclusive to the plaintiffs in Saudi Arabia. That agreement was for the period September 1, 2015 through August 31, 2016, may be renewed annually. The record establishes, and I may get to it a little bit later, that all of the evidence points out that this contract would have been renewed. Mr. Hussein testified that he believed it would be renewed. Gericare had entered into a contract with my client in 2015, the exclusive agreement, and again in 2017, another exclusive agreement for the distribution of calcium carbonate to Saudi Arabia. There's no fact that establishes for any reason that the contract would not have been renewed.
The district court ruled that you sued too late. Can you talk about that?
Certainly. Statute of limitations in this case. What the district court does is it says that the statute of limitations began to run on September 24th, 2017. That was the date of the contract that was entered into between Gericare and HealthStream, the other supplier whom they first dealt with, who delivered more than 800,000 bottles of the product we had the exclusive for to Saudi Arabia. There was no basis factually for the statute of limitations to begin on the date of a contract being entered into that we had no idea even existed for another 2 years. Under the discovery rule, which is the law of the state of Connecticut, Chisholm versus Campagna, which is cited extensively in our brief, until we discover the wrong, the statute doesn't begin to run.
Do you agree that the North Carolina discovery rule is until you discover the wrong, or a reasonable person should have discovered the wrong, right?
I agree with that, yes.
and we have this October letter saying, we have reason to believe there might be a breach coming, please send us a notification that you're not going to breach. That sounds like you're saying we have reasonable person would think there might be a breach
Well,
as of October 15th.
in response, I'd say, having the letter in front of me, the letter does not say we believe there's a breach. We believe that someone may come looking for product.
Right, and then you ask them to please reply and assure us within 7 days that you will not breach the contract. Did they reply to that?
No. They, interestingly enough, they didn't reply to it because the Mr. Friedman I just identified as being the executive VP of sales at Jerry Care testified, we don't like to aggravate our customers.
Yeah, but your argument has to be, I assume, that when they didn't reply to the letter saying, please assure us you're not going to breach, that would not put a reasonable person on notice that they should think something like a breach had happened.
I don't agree with that.
Well,
They
that's
didn't, there
not
was
your-
no,
so your
no
arg-
breach, excuse me, Rona, go ahead.
I'm just saying, your argument has to be, it seems to me, that a reasonable person would not have reason to think that when the letter saying, please assure us you're not going to breach, was not replied to, that no reasonable person would think that means a breach is happening.
I don't believe any reasonable person would think there was a breach.
So
It's
why,
the fact of the
why is
breach.
that?
It's the fact of the breach, the knowledge of anything occurring. There's nothing in
But
the
I thought we
record.
agreed just a minute ago, the discovery rule is not just about when when the breach is actually discovered, it's also when a reasonable person should have discovered it.
Yeah. You can't discover a breach that hasn't happened. That's what I'm saying. That's my position. At that point in time, there was no evidence that we knew about the separate agreement that was reached 2 weeks later with another distributor. We didn't come to know that until discovery in this case.
What about the October 9th, 2015 email that was erroneously sent to your client suggesting or proving perhaps that actually there was a contract with another company? Why isn't that knowledge? That's a JA 1402. That's the email that was sent to the US Med account email, the same account used by the company's
Right.
president, and it lists Rocca, Jerry Care, and HealthStreams as the manufacturer. Why isn't that notice of the breach?
Well, this was sent on January 26, 2017.
I think the email, the document I have in front of me, JA 1402, is dated October 9th, 2015.
That's not the one I have. If you would give me the page number I'm looking for begins with 1386, goes to 1387, then 1250 and 1252 for the
JA
sampling.
141402 is a purchase order, erroneously it appears sent to your client, to HealthStream LLC from Rocca.
Okay.
And it seems to me that that would be notice of the breach.
No, we didn't get that until we got the other document from 2017. That was one of the documents that's attached. You're talking about JA 1252, Your Honor?
1402. It's an invoice from October 9th, 2015.
From whom to whom?
It is to HealthStream from Rocca, but it was erroneously sent to an email belonging to your client, or so it appears.
I don't believe that occurred. I don't have it in front of me, and I will have it here in front of me to testify, to comment on when I get back for rebuttal, but we'll pull that up. Will you pull that up now? Okay. May I continue, Your Honor?
Please.
Okay. So in addition to the discovery rule, we have the continuing wrongs statute of limitation requirements. And in that, the statute does not begin to run until the end of the wrongs are occurred, or have occurred. The last wrong occurred on July 27th, 2017. So that was we're well within the statute of limitations of 4 years for the deceptive trade practice and 3 for all of the other claims in this case. And there's no evidence, and I will look at that document, Your Honor. There's no evidence that we knew of anything before we got the Sampliner documents that talked about a claim by Raqqa, the Saudi Arabia distributor, against HealthStream, the distributor that had been obtained by Jerrycare and Raqqa. So under the continuing wrongs doctrine from Williams versus BCBS, which is cited in the brief, until 3 years after the last wrong, which would have been July of 2000, okay, the statute of limitations is not expired.
Sorry, July of when?
July 27th, I believe it was. But we sued on
Of what year?
2017.
How could that be a violation? I thought the contract ended September 2016.
No, the violations occurred prior, when we had the exclusivity, and during which I believe the record shows the contract would have been renewed for an additional year. So the wrongs.
Well, that's not a breach of an existing contract. That's a different question. The contract we're talking about, the purported contract, is 1 year and it ends in September 1st, 2016. So
Correct.
no breach of that contract could occur after September 1st, 2016.
Well, our claim, I understand your argument. Our claim is that the contract would have been renewed, but the breaches continued, the sales. I understand what you're saying.
So
but
you're arguing for the continuing violation doctrine to apply to a hypothetical future contract that the parties may have entered. You think the evidence shows they would have chosen to contract again?
Yes.
And this would have been a breach of that contract had they made it, and so the continuing violation doctrine applies to a different contract?
No, the renewal of the same contract. That would have gone through.
But how does that continue the breaches of the contract that ended in September 2016?
Well, that contract would have been renewed
With a new, different
with a new
contract.
term. With the whole, no, the contract says it will be renewed.
Well, doesn't it
Okay.
say it may be or can be renewed?
It was not obligatory, but our
So
expectation,
it's
the evidence.
hypothetical.
Pardon?
So it's a hypothetical renewal.
It was hypothetical, but the only evidence that it would have been renewed. So there's no evidence that before my clients received the Sampliner documents in January 26, 2007, and they were informed that there was a dispute between Raqqa and Saudi Arabia distributor and the new distributor here. It wasn't until then that they saw these documents and said, well, there really were contracts, despite the fact that what Jerrycare had done during that whole time was they never said anything about there being a problem with the exclusivity. They cut off all contact with US Med. Jerrycare never informed US Med that we're going to ship it to anyone else in Saudi Arabia. We confirmed, well, we didn't know, or excuse me, Jerrycare took the position, we don't know where the product went, a lie. They denied sales ever went to Saudi Arabia, which was a lie. They said they never gave GC or their products directly to Saudi Arabia. That was a lie. They did it on 2 occasions for over 300,000 bottles of that product. There's no evidence that Jerrycare didn't believe that the contract was valid to us. We didn't know that they treated it as invalid. There's no evidence that USM knew that there were any Jerrycare sales directly to Saudi Arabia. None. There was no knowledge of that at all. So from a limitation standpoint, both on the discovery rule and on the continuing wrongs rule, The statute doesn't run until after we sued in January of 2000. The statute of limitations, again, is 4 years with the deceptive trade practice, 3 years with all others. With regard to the damages, those damages are based upon non-speculative matters that Mr. Hussein's testimony completely verifies. With
You know what that
regard,
red light means?
yes. With regard to the damages, there's no contrary evidence in the record. There's nothing speculative. The format itself is simply what it cost US Med to buy, what they got when they sold it, multiplied by the volume in question. That's the format. No one has addressed the format. That's not a speculative format. If anyone has a dispute with the numbers, then come up and let us know. No one has provided anything in the statement of undisputed facts alleged in which there are violations, which I'll get to in a second. But
Are you using your rebuttal time now?
no, I'm not. I don't intend to, Your Honor. Yes,
Well,
I understand.
The red light means that your time's up.
Okay, I'm done. Thank you.
But you can use your rebuttal time if you want.
No, that's all right. I'll rebuttal. Thank you very much.
You save some time. Mr. Novak?
Is this yours?
Yep.
Okay, thanks. Good. I think it's still morning. I have a cold. It's not COVID, went to the doctor, and it's not a flu. But I'm going to, with the court's permission, I have a bottle here. I
That's
will
fine.
drink it. Thank you. I appreciate that. Also, I did appreciate coming early to hear your en banc. That was an excellent time spent here. I want to just jump into one of the issues which is on the top of your page that you're interested in. I'm not here to defend Judge Flanagan's opinion that Chisholm didn't overrule or modify North Carolina law. But I want to say that I thought she wrote an excellent opinion, because what she did do in her footnote 9 was say, I don't think that it's appropriate in a contract dispute, but even if it would be appropriate in a contract dispute, I don't think it's appropriate in this contract dispute. So I don't think that Judge Flanagan ignored Chisholm, and I think that footnote says that she then, for the next 8 pages or 7 pages, said, here's all the reasons why this plaintiff, Raj Hussain, knew a lot that was going on. I call this case the rope-a-dope case. My client sells pills to anybody who calls up and wants to pay for the pills. What Raj Hussain said in his deposition, that he's been doing these things in Saudi Arabia since 2004. He said that he knows everything that's going on. He knows, he has contacts. He knows how it works. He also said that who gets an award is all public information in Saudi Arabia. And he knew in April of 2015 that his price was too high for the calcium carbonate. He had some other things that they accepted. He knew that, and despite that, in September 1st, 2015, let me get the dates right, 2015, he tells my client, I have the contract for the 86,000 pills, 86 million pills in Saudi Arabia. That wasn't true. He did not have the contract. But he tells him, I need a certain piece of paper that is good just to get the license in. So what he did, he then calls him up and says, I need this one, and that's the first one. That's the first September 1st email and letter. Okay, then what happens is he flies to Saudi Arabia on September 7th because he's told that his prices are too high and he's not going to be, without buying it, Raqqa is not going to buy it for that price. So what he does is he calls up my client and says to my client, I need to change this. The Saudi Arabian Ministry of Health says I need to change the language there to give a new letter that says we have a contract and it's good for 1 year. He said he testified he never spoke to anybody in Saudi Arabia. He's not allowed to speak to anybody in the Ministry of Health. He told them they needed this one letter to go ahead and get a license, an import license. This is something that foreign countries do need, some letters from a manufacturer. He was there on September 7th and 8th, and he was told by Raqqa's Mr. Al-Malik that your prices are too high, we'll buy some of your stuff, but not the calcium carbonate. But if you don't drop your prices, we're not going to buy from you. They had no obligation to buy him. That's, the court said, there was no exclusivity with Rocca whatsoever. He said, I don't care. I asked him at the deposition, why didn't you just drop your price? So he says, I thought they were
So
bluffing.
the district court seemed to think there was a dispute of material fact about whether there was a contract, but the court ruled that this violated the statute of limitations. It was filed too late.
That's, okay.
Do you want to talk about that?
I would be happy to talk about that. I think that what Judge Flanagan said was that either North Carolina law doesn't require the notice period, but I think that's wrong. And I'm not here to
She
argue.
went on to address.
She did address it. And so he addressed it with the examples I get. She said he had knowledge. The plaintiff said he had knowledge. He said it was public information who got the award. So he knew why in April 2015, who didn't get the award and why Rocket didn't get it. He said he had knowledge in September. He had knowledge of why Rocket didn't get the award, and they gave it to somebody else. He said it's all public information. And I think if you have public information, it's their duty to go out and look at that public information. And he said he did it all the time. He testified, I mentioned many times in my brief, that he said, I didn't have contacts there. Now, I also find that Your Honor over there said about the email. The email
Well,
comes out.
Can I ask you about that?
Sure.
Are you relying on that October 9th purchase order?
No,
It's a purchase order, and it's not an email.
it's a
It
purchase.
has an email address on it.
Right.
In your brief, you say they must have received
Okay.
it by email.
Okay.
Is there evidence of that?
No, so I'm not going to rely only on that.
But
No.
is there evidence they received the email?
It's their email address, and.
But it's not an email, it's just an email address on.
Correct,
printed
correct.
on a purchase order.
It
And
was-
it's
it was-
attached- It's an attachment to it's
Well-
page 16 of a 20-page document that's actually from January 2017, right?
Yeah, so
it
we were
very-
given-
It may have been sent, but
we-
I just wanted to find out if there's more evidence
No,
about it. The
so-
district court didn't rely on it, which made me wonder if there
Right.
was more evidence.
Okay, so we got that same piece of paper twice in a discovery. One discovery asked for the documents, and that was when it sent to us and didn't have certain kinds of notations, bait stamps at the bottom. So we got that, then we got it a second time. But I don't think that are relying on that email as his knowledge. I'm thinking.
That's fine. I just want to make sure
Yeah.
I know whether we should
Okay.
rely on it or
Okay.
not.
I don't.
Are you
the
saying
an-
anything more than they might have received?
They might have it, and I just.
But you don't have anything more than
No,
that right now?
I don't.
Okay.
At the deposition, there was a lot of times he says, oh, I didn't send you, Mr. Rogers said, I didn't send you this email, I have a bunch of more emails, but what he did testify was that he's been in the business since 2004, that a lot of this stuff is public information, and even to know what the manufacturer, what the suppliers are, and he knew on September 7th, when Mr. Amalik said to him, I'm not buying that stuff from you, I can go to somebody else. And then I think he got the email, but I don't have proof, but 5 days later, 7 days later, we got the attorney's letter. I don't think my client had any obligation to respond to that attorney's letter. This is not a situation where there's a fiduciary relationship between my client and his client, so I don't have an obvious obligation to do it. Secondly is that he called up about, I don't know, in December, the date of December 15th.
So that October 15th letter is the one where the attorney said,
Right.
tell us in 7 days you're not going to breach.
Mm-hmm.
And your client didn't say anything in response.
That's right.
Okay.
And I think
That's
that,
bad form, isn't it?
well, that's why they hire,
bad form.
that's why they hire lawyers.
It's
If they,
discourteous.
it is discourteous. And if they didn't hire lawyers, if they hired lawyers before, maybe I would never be here. And this case would have never gone, it was discourteous. However, I do think that it shows the plaintiff that he's not abiding by it, or he's not responding and saying, oh, yeah, sure, we understand it. Then in December 15th, there's a conversation, there's an email from Mr. Hussain. He says, I want to maybe buy some more of this calcium carbonate. And my client says, well, what country are you sending it to? And he says that, well, I'm sending it to Saudi Arabia. We have an exclusive relationship. That conversation ends, and they have no more response back and forth. So is there a lack of courteousness? Yes, but do I think that there's an obligation, a fiduciary obligation? Was it fraud? No. My client did not believe that it really had a contract exclusivity because Mr. Hussain never came through in the letter. It says, we have a contract. That contract wasn't the exclusivity contract, that was the contract that he was supposed to have, which is how many pills you're buying and how much you're buying it for. So when Mr. Hussein found out on September 9th, while he was in Saudi Arabia, that he's not going to get the contract, he didn't call up my client and say, oh, I don't have the contract. But he thought that he would just hold on to this September 9th email, though it's dated September 1st, and so that at some time later, even after he does business with my client in 2018 and 19 and buys pills, he will sue him. And that's what he did here. I think he waited too long. The exclusivity contract was only through either August 31, 2016, or September 1, 2016. You have a 3-year statute of limitations down in North Carolina, so he didn't sue until the summons complaint, which is in 2020.
Why doesn't the continuing violation rule apply?
So first thing, okay, the continuing violation will apply, as I understand it, is that there's a series of, you have this case that we have, you have a series of cases, you have a series of different things they're doing, not that there's one contract and it's just different tranches of payment stuff. So, but I think the only violation with regard to HealthStream, that all occurred within that 1-year period, and what plaintiff or appellant wants to do, he says, no, well, we would have renewed that contract, and then for that contract period in 2016, 2017, you're selling it to other parties, not HealthStream, because the Saudi Arabians didn't pay the money to HealthStream, and because they didn't pay that money to HealthStream, that contract also blew up, which is the reason why, with regard to the computation of lost profits, it's so nebulous, it's so uncertain. There's so many different parties and players out there that could change their mind. The Saudi Arabian government has the right to change its mind, which it did, which at least Mr. Raj Hussein said it happened from time. Raqqa would not necessarily pay somebody, and Mr. Hussein said in testimony, he said, well, I didn't really have a fixed price with my client, Jerry Care. That's something I would have negotiated after I got the contract, meaning after he got the purchase order from Raqqa. But until he got that purchase order from Raqqa, he said he would never sign any kind of purchase agreement with my client. 2 times I asked him, why didn't you renew the what you believe is that lockup period, that exclusivity? He said, well, I really couldn't do it because they would never have agreed, because I never bought a contract with them. I never bought any produce from them. So it's not that, oh, maybe I would have done it if this would have happened, that one. None of that happened. And he didn't even call up and say, I want to renew the contract. So I don't think that the theory that the contract could have extended for another 10 years or another 2 years or something like that, had he done it when he said, I didn't do it. So you can't extend a contract just because you want to in your head. So therefore, since the period of the lockup ended on September 1st, 2016, we really had to bring the lawsuit before 2019. That's that 3-year period. So they didn't do that. That's our main argument on the statute of limitations.
When exactly, on what date do you think they received notice of the breach, or they should have known of the breach?
I actually think they knew it before he left Saudi Arabia, because all this is based on what Mr. Raj Hussein said to us. Everything is public information. Who the supplier is of the produce is public information. So I believe that when he walked out or got on the airplane and came back to North Carolina, he knew, because he was told by Raqqa that I'm not, and there's an email like that, I can show you the email that says, we're not buying it from you, we're going to buy it from somebody else. And if it's public knowledge that, meaning he said it's public information in Saudi Arabia, you can go online and see who was awarded the contract. So when do I think the breach occurred? I think the breach probably occurred on my client. If that agreement, that one-page letter, that September 9th letter, which I don't think it is an agreement, but Your Honor said at least as a question of fact, is an agreement that it would have occurred the first sale that was made to HealthStream. And then it would continue to the last sale to HealthStream, which is in February of 2016. And then, so those would be all the breaches that could have occurred, but I actually don't understand what Mr. Farrell's argument is about the continuing breach after the 2016 lockup period. They didn't have a contract, and then the contract was no longer with Hellstream, it was with a different company called Pharma Med. I don't really understand how that all plays here. I think that the statute of limitations is a pretty solid argument that, at best, it had to end when the last sale was made during that lockup period, and those all ended in 2016. With regard to his claim of the fraud, generally, I don't think the fraud in a contract is really very, very unusual that courts ever feel that way. Moreover, I don't think my client had an obligation to talk to him. My client was probably pretty unhappy with him that he calls him up and makes him crazy and says, I'm going to do this and do this. We have a contract. And then he just disappears after September 9th and doesn't call him back and say, I didn't get a contract, maybe next time. So with regard to Your Honor about courtesy, okay, there's a lot of, I guess, non-courtesy in business. However, 2 years later, when he now knows already that my client sold everything to HealthStream for that 1 year period, he has no problem going back to Jerry Care, entering to another agreement to sell, 58 million pills. That's pretty much, I see that. I have more time, but that's our case. I mean, as I say, we're sticking with the statute of limitations, and even if we lose on the statute of limitations, Her Honor said, I think quite well, that there's no way that there's can be any kind of damages of loss of profit on this. Nominal, North Carolina seems to say nominal damages only in case of fraud or breach of fiduciary liability, and there are no cases that say when you have two competitors or two business people that have no relationship, that they have to respond to each other, that quiet silence is deemed to be fraudulent. So, thank you very much. I am finished. I have a little extra time. But
Thank you very much, Mr.
Thank you.
Novak.
No, thank you.
Good to have you with us.
It's a pleasure. I'm glad I came down here.
Yeah, Mr. Buckmiller?
May it please the court, Matt Buckmiller for the defendant Rocca. Our initial position is that the plaintiff has waived all arguments as to the propriety of the granting of the motion to dismiss as to Rocca for failure to raise any of those issues in its appeal. There's numerous claims that were dismissed by the trial court. A tortious interference with contract, Chapter 75 claim, breach of fiduciary duty, and additional claims as well. The only argument that appears to be somewhere in the appellant brief has to deal with a tortious interference with contract claim. There is no argument whatsoever as to any of the other claims that were dismissed by Judge Flanagan. And according to this court's rulings in Southeastern Public Safety Group, U.S. versus Bailey, Mod Perfections versus Bank of America, you need to develop your argument, and if you don't develop your argument, you have to give it more than a passing shot. And if you don't give it more than a passing shot, then the argument is waived. So we contend, first off, that the appellant has waived all of its arguments to contest the granting and the propriety of the granting of the motion to dismiss.
And they didn't dispute that in the reply, right? You said that in the red brief, and then in the reply, they didn't come back and say, no, you missed a giant place where we argued tortious interference.
Correct. It's been absent. And I will just remark briefly on the tortious interference claim. I'm not going to get into the damages issues or the statute of limitations as to a breach of contract. What I will say is the statute of limitations for a tortious interference claim with contract is still 3 years under North Carolina law, and it is not subject to the discovery rule. There has not been a case at the Supreme Court since Chisholm versus Campana, which I've happily represented them both in different cases, but that is still the law in North Carolina, that there's no discovery period under the tortious interference with contract claim. I will also note that, as the court had indicated, the contract was for a year, so the contract would have expired September 1st, 2016. The lawsuit was filed 1/23 of 20, So that is way past the 3-year period of when they would have had to have filed this lawsuit. The claims in the lawsuit are not for tortious interference with prospective contracts or with prospective contract rights. It's simply a tortious interference with contractual relationship. And also, if you look at the complaint, which is on Joint Appendix 24, it lists the violations by RACA, this tortious interference that's alleged, occurring from September 21st, 2015 through March of 2015. Well, so it goes back in time before the contract was entered into. Now, even if you were to extrapolate from the record, from the purchase order that we saw, that there was some conduct in October of 2015, that still is way past the statute of limitations on when the action needed to be filed. Thank you.
Thank you, Mr. Buckmiller. Mr. Farrell,
Thank you, Your Honor.
now you got your rebuttal time.
With regard to the document 1402, the purchase order you discussed before, Judge Berner, that is an email address that's on another invoice. It's not an email to which this document was sent. And there's no proof that my client ever received that document. The documents they did receive regarded the dispute between HealthStream and RACA between themselves over performance of the initial contract that lasted until August 31, 2016. When we talk about the certainty or uncertainty of damages, Your Honor raised a good point about when does the discovery or the continuing violation statute end if the contract ended on August 31, 2016. If damages are determined that don't include any renewal period for damages, then that's a fact determination. It does not make the damage calculation speculative in any way. As a matter of fact, it makes them absolutely certain because the contract violations that weren't discovered until later began after the HealthStream contract on the 24th. We never discovered those violations, but during that 1-year period, the plaintiffs are entitled to what would be determined factually was the period during which they have a right to receive damages. And in that period, they took actual pricing, the actual purchase price, actual sale price that had been agreed to, which is 93 cents. They were purchasing for 58 cents from Jerrycare, and at that point in time, the difference between their purchase price and their sale price, since there was no overhead delivery cost, as is set forth within our statement of undisputed facts, the damages would have continued until and through into August 31, 2016. That would be the period which they had the later discovered violations, and the damages could be computed mathematically, and they're presented within the record. The document page numbers are set forth in our brief, and with that, the additional point is they're saying they've said all along that they could, the RACA company that was the original distributor in Saudi Arabia, could have purchased the product from any place. Well, that's not true because the contract required them to purchase Jerrycare product with regard to the governmental entity and RACA, and the record is clear on that. Lastly,
Can I ask you
Yeah,
just
sure,
to follow up on RACA's presence here at oral argument? Are you appealing any issue other than the breach of contract and the UTPA ruling?
with regard to Jerrycare,
With regard to anybody, the district court ruled on all your claims, but in your brief, I just saw you challenging the district court's breach of contract ruling and UDPA ruling. Is that right?
you mean the
Unfair
deceptive trade practices?
Yes, that's right. Sorry, it's a lot of letters.
Yes. I believe that's true with regard to the breach of contract and the Deceptive Trade Practices Act. We're pursuing those, as well as the fraud. We're claiming the fraud claim as well, but fraud is part of the DTVA claim.
Fraud is your, the unfair act that you're claiming for unfair and deceptive trade practices. Okay.
That's correct.
But no other claims are you appealing?
Right.
Okay.
So far as whom the purchases had to be made by, the purchases in question that violated the contract were all comprised, each comprised a breach of the contract. If we just take the period, without considering renewals, if we just took the period September 1, 2015 through August 31st, 2016. They couldn't, we had a right to get pricing and sales from any sales that went to Saudi Arabia were our exclusive sales. And the sales that were made were the sales that are in dispute today. Sales by Jerry Care to another distributor for distribution in Saudi Arabia. We know what those volumes are, but we're entitled also to what the agreement was in the volumes that were to be required to be delivered to Raqqa in Saudi Arabia and to the Saudi Arabian Minister of Health. There are comments made about public records that were available to the plaintiffs. There's no evidence in the record that any of those public records were ever available actually publicly. There's no public records that evidenced the issuance of a contract to, or any type of contract that would have given us notice that our rights under contract were violated. And this was the problem with regard to the statement of material facts that the parties respectively filed. All we received was a comment that said, a response that said, dispute, we dispute this. There was no record evidence there, nothing stated except for one out of 77 disputes. They referenced any evidence. If that's the way the rule is going to be administered for summary judgment, then I don't believe that that's an effective way to implement the intent and purpose of the rule. Thank you.
Thank you, Mr. Farrell. Appreciate you being here. We'll come down and greet counsel, and then we'll go to our next case.
Okay.
Nice to be here.
Good to see you.
You are a congenial court. I went online, they said you are. I've never had this happen in the Second Circuit.
blatantly contradicted by the record, and in finding that minor discrepancies in testimony created a dispute of
This
material
is an
facts.
interlocutory appeal.
Yes, it is.
Denial of a claim for qualified immunity?
Yes, yes, it is. Yes, it is, Your Honor. And in particular, when we look at some of the issues in the case, one of the issues that we found was that to the extent that the court found that there were any kind of disputes of material fact, there were three areas in which the court found disputes of material fact. One related to Smith's movements on the screened-in porch.
Well, the stories were directly contrary to one another.
They were not, actually, Judge, and that's the point. They were not.
Okay.
And I'd be happy to explain how.
Well, the judge thought they were directly contrary to one another.
And I think that that's one of the issues that we have on appeal.
Judge
Urbanski. And he's a great judge.
For that reason, he said you needed a trial.
That's right.
For that reason, he said you deny a qualified immunity claim.
That's correct. And so, Judge, but...
That's the whole case. And,
well,
and the Supreme Court gives you right under Mitchell versus Forsyth all the way back to appeal that denial.
That's correct, Judge. And so that the ability for us to appeal that denial actually comes because we are appealing a denial on the basis of an area of law. We're not asking the court to weigh the facts. We're not asking the court to determine who was correct and who wasn't correct. It's with respect to the court's finding that there were material facts in dispute, however, there is both United States Supreme Court case law and Fourth Circuit case law that deal with areas where the testimony is blatantly contradicted by the record, the physical and photographic evidence in the scene.
But we're not, I mean, it's not just that we don't weigh the facts. Nobody weighs the facts at summary judgment anyway.
Right.
Our cases say we have to take the facts as the district court stated them.
Correct.
Which means when the district court looked at the record and said, I think there's evidence to support this fact and that fact and that. Now, whatever a jury may find one way or the other, but there's sufficient evidence for all of these facts, and the district court lays those out, and then we accept those, and you have to accept those, and then we construe them in the light most favorable to the plaintiff and ask, would this be a constitutional violation, and was it clearly established?
Correct.
So is that what you're doing on appeal?
Yes, there is an entire area in terms of we're alleging that there was a denial of qualified immunity that was an error as a matter of law. But in terms of those fact issues, Your Honor, I think the point that I'm trying to make is if you take the entire body of facts that were stated in front of the court, and we accept that those are the body of facts, I think that there was error by the district court and not disregarding facts that were blatantly contradicted by the evidence in the scene.
Well, we don't have interlocutory review to review the district court's assessment of the facts.
Well, if it comes to a point of law, and that's the point that I'm trying to make.
Well, I guess that's my question, is just understanding the scope of what you're arguing. Do you contend that Jennings did not violate Smith's clearly established Fourth Amendment rights if he shot him and Smith was not in a shooting stance, was not advancing, was not making tactical maneuvers, was not directing a gun or a flashlight at Jennings, and the flashlight wasn't strobing? Accepting all those facts, do you say shooting him in that circumstance was not a violation of clearly established law?
Your Honor, I do not.
Is it yes or no?
Under those circumstances, that would be a violation of clearly established law.
So that's the only question in front of us. That's the only thing we have jurisdiction to decide, because those are the facts as the district court presented them. The district court said a jury could believe all those facts I just read, and the only thing we're allowed to decide is, would that be a violation of clearly established law?
So
if
you're
not challenging that right now, you can challenge, later once the facts are sorted out, you can come back on what the facts actually were. But except all of those are the facts, I just read them from the district court's opinion. And if you're not saying the district court erred as a matter of law on all those facts, then we have no jurisdiction.
So I understand what the court is saying, and I guess in terms of clarification, what I'm arguing is that the court made an error in determining that it could it could review certain facts. And that's the point of a law that we're talking about in terms of disregarding, so for example, and I'll give you an example from the facts, and if the court does not want to hear that I understand.
Well, my colleagues may want to hear all sorts of things. I
Okay.
just wanted to ask about that.
Sure.
So I understand the scope of your claim.
Sure.
When I was looking at your argument about the clearly established law, it did look like it depended on taking the facts as you view them rather than as the district court viewed them. But if you thought that even in all these circumstances, it wouldn't have been a violation of clearly established law to shoot him, then that's a different argument. But you seem to agree that based on the case law, that's an argument that can't be made.
Well, I would agree that if an individual is standing on his porch doing nothing, then no, an officer can't shoot him.
Sure.
I think that's black letter law. I wouldn't be here to make that argument. But the argument I'm making is a little more nuanced in that, so we have Scott v. Harris out of the Supreme Court, which states that the district court is not to give credit.
Saucier,
I'm sorry, Your Honor?
Saucier,
Scott v. Harris. So that's the case
Okay.
in which the court found that if the record as presented, the photographic evidence, the video cameras, all of that evidence blatantly contradicts testimony provided by a witness, then the court is to not give credit to the testimony for the purpose of summary judgment. And that is one of the issues that we raised. We had a situation in which there was testimony provided by the neighbors, which stated that, for example, there was no movement on the porch by Mr. Smith. He stepped outside and stood exactly where he was, but we have a photograph of the body indicating that he was laid flat on the ground and he's 6 feet tall and his head is several feet from the door. So the evidence on the scene, the physical body on the scene, disputes Mr. Huff's testimony that there was no movement by Mr. Smith on the porch. And so when I'm looking at it in terms of the misapplication of the summary judgment standard, in terms of what Scott v. Harris says the district court has to do in terms of disregarding evidence that's blatantly contradicted by the record. The second point on that same misapplication of the summary judgment standard relates to differences in the Anderson v. Russell case, where the court indicates that the district court cannot create a triable issue of fact where a witness testimony differs from a police officer's when the witness has a disadvantaged viewpoint. And so our argument with respect to these facts that the judge found to be in dispute were that if the judge had properly applied Scott v. Harris or had applied Anderson v. Russell, then those facts would not be in this discussion at all. And then when you're left with the remaining facts, then as a matter of law, yes, Mr. Jennings is entitled to summary judgment.
So you're saying the court was wrong to find a dispute of material fact on those?
Because the court didn't apply Scott v. Harris and Anderson v. Russell.
And I will stop harping on this and let you talk about other things, but don't we have cases saying on interlocutory review, we can't review whether the district court was mistaken that there was a dispute of material fact? Otherwise, we could review every single denial of summary judgment.
Absolutely. But you also have cases where on summary judgment, the court looks at whether or not
you want us to review the facts, so what standard of review do we have? You claim we have a right or power to review the factual recitation.
So
Under what standard?
So when there's an appeal of a summary judgment ruling, then the standard on review is de novo.
This is an interlocutory appeal from a
That's correct.
denial of the qualified immunity.
Correct. And so the court would look at these facts and look at these applications of law de novo. And the issue on qualified immunity, again, it's like.
You're saying we should look at the facts de novo.
I'm sorry. I'm sorry, Your Honor.
All right.
I'm saying that you look at it's a point of law, and you look at the point of law de novo, and you take the facts as the district court found them. That's the standard. But when the area that gives rise to the concern for qualified immunity, the denial of qualified immunity, arises when there is a misapplication of the standard that gave rise to the denial, then there's a point of law there that's being contested, as well as the denial of qualified immunity in that Officer Jennings' actions were reasonable. And when you look at the reasonableness, of course, you look at the Graham factors, the most prescient of which being, or excuse me, the probative of which is Factor 2, which talks about whether or not there was, in fact, a substantial risk of imminent harm to an officer or others. And under the facts that are presented, the totality of the circumstances, starting with the nature of the call and the efforts to resist complying with the officers, the 3 different interactions that Mr. Smith had with Mr. Jennings, including escalating behavior, where he comes out first armed with a baseball bat, then armed with not armed, but having his hands underneath his shirt to mimic a weapon, and engaging with Mr. Jennings in that point, telling him.
He as much as told him he had a weapon, didn't he?
He as much as told him he had a weapon. And in fact, he told Mr. Jennings, Officer Jennings, that if, that he could shoot him because he knew where he was in the yard based on the location with his flashlight. That's the last thing that Mr. Smith said to Mr. Jennings before he returned into a darked out house and came back seconds later with a flashlight that he was holding in a position like this. Now, if you look at the positions from which the respective parties were viewing the scene, the Huffs were reviewing it from 2 different windows that were at different elevations, nearly 2 stories above Mr. Jennings. And if you compare the photographs, the screens that were taken from the plaintiff's brief, showing that angle of that flashlight, it's nearly identical. And so one of the issues that we raise is that the court could have, as a matter of law, decided that the facts that the Huff said were not something that could create a triable issue of fact under Anderson v. Russell, because they have a different vantage point that's disadvantaged. They're 2 stories high, and they're looking down into a darked out room, and Officer Jennings is in a different location looking up at Mr. Smith and in the dark. So we argue, of course, that there's...
Under your argument, you may well win the trial. But the question here is whether we got jurisdiction.
I understand that that's the question of the court, and I understand that the court's asking me to look specifically at qualified immunity. And I'm saying in order to get to qualified immunity, we have to first look at whether or not there was an error of law that gave rise to the inclusion of these facts. And that's where, I guess, the rubber meets the road in terms of the argument. If the court applied Scott v. Harris to disregard testimony that was clearly contradicted by the physical evidence on the scene, or if it applied Anderson v. Russell to determine that these witnesses were at a disadvantaged location and couldn't see the same scene that Officer Jennings could see, then in that case, those facts actually go away. Those facts go away, and then you're left with the facts that were presented that are frankly supported by the evidence on the scene that Officer Jennings testified to.
These facts go away. You sound like those facts should be disregarded.
Yes, Your Honor.
In your view, the only facts should be what your client said.
No, Your Honor, not at all. What I'm saying is because the only thing that matters is if there's a genuine dispute of material fact. And so if there's not a genuine dispute because those other facts cannot be considered by the court.
That's what you say, you don't want them to be considered.
Because
that's what appears to me, and that's your point. They shouldn't even be considered.
To the extent that, but only, Your Honor, to the extent that they conflict with the physical evidence on the scene that's uncontroverted. And so when you're looking at that issue.
But Judge Urbanski ruled they had to be considered.
Judge Urbanski did, and that's the error. I think the judge erred in finding that those facts could be considered under the summary judgment standard. So really that issue, that first issue, is whether or not Judge Urbanski misapplied the summary judgment standard, finding, and looking at the issue of the flashlight, whether or not it was strobing. So whether or not it was strobing was not even a material fact. Judge Urbanski recognized that in an oral argument with counsel. So there were issues that came up in terms of the court's determination that there were facts in dispute, but those issues were based on points of law that we're asking the court to consider that this judge did not review correctly in making these determinations. Thank you.
Thank you, Ms. Royer. You got some rebuttal time, too. Mr. Grimes?
May it please the court, good afternoon, Your Honors. We're here on an interlocutory appeal. Judge Rushing has hit the nail on the head, laid out the facts as stated by Judge Urbanski below, and asked counsel whether, if those facts are taken as true, a violation of clearly established law has been established, and counsel answered yes. That's the end of the story in this interlocutory appeal. This court has no jurisdiction to entertain this interlocutory appeal. Now, it may, in the future, after trial, review a set of facts, but not today. My opponent has turned the standard of review on its head and argues, in essence, that in order to prevail, that you have to take the facts as they're presented by Officer Jennings as a matter of law, which is not the standard of review. And what she's presenting here is a jury argument, as you have noted, Judge King. Frankly, there's nothing more that I need to say, but I can march through Judge Urbanski's opinion. I'll be doing nothing but reiterating what you said, Judge Rushing. So please stop me at any time as you see fit. But that's this case in a nutshell. It really does not require anything else than what I have already said. Nevertheless, I will march, and we can argue over the facts, as you have noted, Judge King, but that's for another day. That's not for today. That's for a trial by jury. Well,
there are two prongs in the analysis. There's the prong of whether there was a violation, and then there's a prong of whether there was a clearly established right.
right.
And I think the question of whether there was a violation certainly is a genuine issue of fact, and we have no jurisdiction to review. But what about the second question as to whether there was a clearly established right? Because that generally is a question of law.
This court has addressed that a number of times in Aleman versus City of Charlotte, and I believe you authored that opinion, Judge King. And we discuss all these cases on brief. Nibbs versus Momfard, Cooper versus Sheehan, Hensley versus Price, and the Supreme Court case of Tennessee versus Garner, which in 471 U.S. 1 in 1995 opinion, where the court said, in essence, a police officer may not seize an unarmed, non-combative suspect by shooting him dead. Non-cooperative suspect by shooting him dead. So there's your violation of law, Judge Berner.
So we can reach that issue. We can affirm that we can find that there was a clearly established right.
You can find there's a clearly established right.
Are you agreeing that that's being challenged? I thought I asked your friend on the other side whether they're arguing it's not a violation of clearly established law to shoot a man who's not presenting any of these facts that the district court said, and she said, no, we're not arguing that because it's so obvious that it is clearly established. So I thought she said that question's not before us.
That question is not before you.
Okay.
I agree with you, Judge Rushing. That question is not before the court. They're not arguing it. She answered yes to your question.
Right.
That's the end of the story. Honestly, what else is there to say? I have much more to say, but I see no point. I'll answer any questions the court may have. It's clear. This court does not have jurisdiction. My opponent's trying to turn the standard review on its head. That's where we are. Nothing further. I'll stand down.
Thank you very much,
You're welcome.
Mr. Grimes. Good to have you with us. Ms. Royer, you have some time.
Thank you, Your Honor. And I want to pick up with respect to the right being clearly established and Judge Rushing's comments. When I answered the judge before in terms of whether or not somebody standing on the porch not engaging in any conduct could be shot by the police, of course that is clearly established. You cannot do that. But I think that when we look at whether the right in question was clearly established, we have to consider all the other information that was before Officer Jennings, even if you take all of the facts, the district court found them as they found them. We have to also consider the fact that at the time the officer was responding to a call for a domestic with a weapon, that the individual not contested facts. The individual had indicated that he was armed. He had already came out at the street level with a baseball bat. He had specifically told the police officer that he could shoot him if he wanted to. All of these things are not disputed. And in fact, Mr. Huff, the neighbor next door, specifically said he found that to be a threat to the officer when he was examined by counsel. So when you're looking at whether or not there was an imminent threat to the safety or security of officers, I think that there is enough information in the record, even if you accept that these disputed facts are the way that Judge Urbanski set them out in the opinion, in terms of determining that the courts can apply.
So can you show me where in your brief you argued, if we accept all the facts as Judge Urbanski stated them, we still argue that there was not a violation of clearly established law?
So to specifically on that point, I think that the argument comes in under whether or not the right was clearly established. I will admit that in analyzing it, I analyzed it in terms of whether or not the court identified the standard correctly, in terms of whether or not the right was one in which an individual had the right to stand on his porch.
You disputed the assessment of facts. You said we disagree with the district court's assessment of the facts that are relevant to this question. And if the district court had assessed the facts relevant to this question under the correct summary judgment standard, then we think there would have not be a violation of clearly established law.
Well, I think that I specifically said that I think the court stated the clearly established right incorrectly based on the facts that were available to the officer at the time. And that includes all the facts, right? So, but I'd ask the court, even if you set aside the things that are disputed for the purpose of this argument, there are things that are not disputed that still give rise to a concern that there was an imminent threat to officer safety. And that's why when we're looking at it, of course, the question is whether or not that threat existed at the moment, the time that force was applied, but you have to look at all the information that was available to the officer on the scene. And that is certainly something that this court has said is necessary. And that's why when you look at the information that was available to the officer giving rise to the shooting, even if you'd say that he was standing still on the porch, but he still had that flashlight, it's not disputed that he had a flashlight and that it was on and it was pointed out into the yard, right, where Officer Jennings is located. Even if you take that fact, even if you take the fact that the record of the recording indicates that Officer Jennings asked him what that was attached to, the light that he had, what was it attached to, that Smith taunted Jennings and said, "I don't know, you tell me, am I pointing at you?" When Jennings asked him if he was armed with a gun, he said, "I don't know, you tell me." And so under the circumstances, Jennings did tell him to drop his weapon. He refused to drop his weapon. When you take all the information known to the officer at that point in time, that last exchange in and of itself would be sufficient, even if the facts were such that Smith was standing on the porch flashing a flashlight at him, whether it was strobing or not, it was on, and that is undisputed, and engaging in this conversation as to whether or not he had a gun and whether or not he was going to use it. Now, if you look at the precedent in this court, obviously having a gun in and of itself is not sufficient to determine there's an imminent threat. There has to be some furtive action taken with it. When you take the actions of the decedent that are not disputed, the record from the recording, the conversation that they had, he was threatening and made every effort to make Officer Jennings believe he was in fact armed. That goes back to the second interaction on the porch where he was making finger guns under his shirt, not disputed. It goes back to the first interaction where he had a baseball bat, not disputed. So when you take all of that information and then in the moment where force is applied, you have an individual who refuses to state he's not armed, officers asking him if he's armed, asking if he has probable cause to shoot, telling him to shoot. Under those circumstances, when there is in fact an undisputed flashlight, I do believe that the fact's sufficient to grant qualified immunity on that issue with the undisputed facts. Thank you.
Thank you, Ms. Royer. We'll come down and greet counsel, and then we'll adjourn court for the day, Madam Clerk.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.